This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about an unusual kind of insurance fraud and how gangs involved in criminal activity use fraud to fund their purchase of weapons and engage in murder for hire, and why the gang defendants who were actually arrested by the United States and charged and about to go to trial have presented multiple motions to avoid or delay trial for COVID-19 fraud and murder for hire. In United States of America versus Ronnell Bowman and Ronnie Jackson, the United States District Court for the Eastern District of Wisconsin, on October 7, 2024, dealt with motions from the defendants who were charged with conspiracy to commit murder for hire and using a firearm during the commission of that offense, with participating in a conspiracy to possess, sell, or transfer firearms in various illegal ways, and charged with both substantive mail fraud and mail fraud conspiracy. Each defendant, a month before trial, filed multiple motions, including that they moved for a bill of particulars requesting further information about acts they allegedly committed in furtherance of one or more of the conspiracies in which they allegedly participated. Each moved to sever the charges of conspiracy to commit murder for hire and use of a firearm during the offense from the other charges that they are facing. Jackson moved to compel disclosure of any reports by and the identities of cooperating witnesses. Jackson moved to dismiss the firearms conspiracy charge, and each moved to strike language in the indictment as prejudicial surplusage and a scheme to defraud the United States to obtain millions of dollars in COVID-19 unemployment insurance benefits to which they were not entitled. The introductory section of the indictment alleged that defendants and others were members of a street gang, the Wild 100s, in the Milwaukee, Wisconsin area, and as part of that gang, engaged in crimes of violence, gun and drug offenses, fraud, and other criminal activity. Not a very nice group of people. The government specifically characterized the gang activity used the fraud proceeds to fund their gang-related activities, including engaging in multiple firearm offenses, soliciting a murder for hire. And since the grand jury returned the indictment of April of 2023, the government has turned over a large amount of discovery material to the defendants and their co-defendants, representing in March of 2024 that it completed its discovery production. The defendants' motions were designed to delay and to make more difficult the prosecution. For example, a bill of particulars is unnecessary where the indictment sets forth the elements of the charged offenses and provides sufficient notice of the charges to enable the defendant to prepare his defense. And since the case is set for trial about a month from now, it is a little late. The defendant's motion to sever counts was also brought forth, and the court noted that mail fraud is obviously different than firearms offenses and murder for hire, requiring the government to prove different elements and to prevent different evidence. The court accordingly disregarded the defendant's arguments for joinder because it is improper on that basis. The government's factual profile in its opposition brief, in which it indicates that it will introduce testimony that illustrates a direct link between defendants participating in a fraud scheme with their participation in murder for hire and firearms offenses. While it is true that the mere fact that two conspiracies have overlapping memberships will not authorize a single indictment if the conspiracies cannot be tied together into one common plan or scheme. The government has done more than just assert overlapping membership. The government has asserted that other conspiracies flowed from and indeed were made possible by the initial mail fraud conspiracy. That, in the court's view, was sufficient to support joinder of all the charges. For all these reasons, the court found that joinder of all charges asserted against the defendants is proper and will serve the interests of judicial economy by furthering efficient resolution of this case. The court further rejected any argument that the charges should nonetheless be severed. The government will not be able to prove the murder for hire offense by simply asserting that defendant funded it with the proceeds of the mail fraud conspiracy. The government will have to prove two distinct elements for the defendants to be convicted. The court therefore denied each of the motions brought by the defendants. In my opinion, this case, going to trial shortly against gang members, explains that violent criminals who enter into murder for hire schemes fund those schemes with nonviolent fraud. The COVID-19 giveaway schemes from the U.S. government, with little or no controls, was so easy that even gang members were able to get rich from the government programs and other types of insurance fraud to fund the purchase of firearms, machine guns, and engage in murder for hire activities. That they were arrested and will go to trial on the fraud scheme should give the public some comfort that the government is getting around to fight fraud, because it really is a violent crime, and if it isn't a violent crime, it funds violent crimes. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 4,900 blog postings. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. They're all free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.